Welcome you all to the lecture series on corporate law. The lecture series on corporate law, we will be discussing in this lecture on the contents of the prospectus and liabilities, because the earlier lecture we have discussed on the prospectus, its meaning. Now the another prominent important concept, how the prospectus have to be drafted. What are the components, or we can say in the simple language, the contents in the prospectus? We will discuss this from looking the perspective of the Companies Act 2013, how the Companies Act 2013 talks, and what are the provisions are there in the company law, followed by the practice, the purpose, and the principles, how the prospectus should be there. In the case of any misstatements, untrue statements, liability for those statements as per the law, as per the principles of law, and as per the rules of law, we will discuss in this particular lecture which we have decided to discuss on prospectus and the contents of the prospectus. Now let us move on to the section 26 of the Companies Act. Section 26 of the Companies Act provides and says that every prospectus issued by and on behalf of the company, it should contain certain silent features, right? So Companies Act 2013 laid down certain silent features of the prospectus, and in this prospectus we can see that what are those silent features, and it is applicable if the prospectus, when it is issued by the company, that is if the company itself or any other person on behalf of a public company on its formation or the subsequently. This I have given an example. If A Limited on its own, A Limited if appoints some merchant banker or registrar to an issue, so they will prepare the prospectus, or any authorized persons authorized by virtue of the company to prepare the prospectus, they have to mention certain important informations. They have to provide the important information for the knowledge of the shareholders. Now let us see these. What are those silent features? What are those main components? The first and foremost is that the name and address of the register office of the company should be mentioned. So the first concept or the first subheading is that name and register office of the company should be mentioned. And number two, dates of opening and closing of the particular issue, because it's very important. The name of the opening of the public issue as well as the closing of the public issue need to be mentioned in the prospectus, whereby the prospective shareholders, the prospective subscribers may understand the particular date of closing of the prospectus and how the company is making the issue, either for a period of 10 days or 15 days, and the people will come to know the closing of the issue as well as opening of the issues. And the board of directors of the company are supposed to create the separate account where they have to keep all the money, or the money which has been received by the shareholders, or the money which is supposed to be given to the shareholders, depending upon the nature of issue, that they have to prepare about the board of directors separate bank account. And another prominent important, who are the underwriter to the issue. So underwriters are the people who take the responsibility in the case of lower subscription or under subscriptions. That means if the company want to sell 100 shares, if only 50 people are ready to buy, who will take another 50? I will repeat. If the company want to sell 100, only 50 people are purchasing the 50, there is a balance of 50. In that case, the whole issue we can say underwriters. That means shareholders are not coming forward to take the public issue. In that case, the company at the disadvantage, company may not be getting the ample number of people to subscribe. So therefore, to avoid these circumstances, the company will appoint registrar to an issue. Otherwise, sometimes we call as the underwriting of the issues. So the first one is the registrar office and opening and closing of the issue, separate bank account and the statement by the board of directors, and number 4 about underwriters. Moving further, point number 5, in any prospectus, the shareholders who are subscribing to the company's prospectus are the investors. If Mr. A, right, if the Mr. A is the investor, he is purchasing the shares in A limited company, he will see that who are the directors in the company. If the famous names are there, or well-known directors are there in the companies, so people try to print their names. By looking the names of the directors, the public or the investors will invest into the capital of a particular company, and therefore it is very necessary that the directors have given a consent to be the directors of the company. So the prospectus contains the consent of the directors, name of the directors, who are the auditors, banker to an issue, and who are the experts for a particular public issue. If the company is raising the capital through the private equity, or you can say private finance or a public finance, then there are sometimes they take the expert's opinion with regard to the value of the companies. So therefore, the clause number 5 also talks about our information to the investors to understand that there is the people who are the directors of the companies, and just mentioning of the name would not suffice. After the mentioning of the name, we also require the consent of the directors or the experts, because it makes a lot of legal obligations. Legal obligation in the sense, if a director name is there, to what extent director becomes liable or not liable also. Then point number 6 about the resolution of the company, where the company has taken the consent of the directors, stating that the company is going for the public issue. Then allotment for the time schedule for allotment of securities, whether it is 45 days or 1 month, or what are the time which you have with timeline factors, that's otherwise called the schedule or the of the public issue have to be mentioned. Therefore, the investor is aware these are the time schedule. In the case of breach of the time schedule, that they can file the case. Then moving on to the another one, capital structure of the company, which are prescribed manner. Capital structure means whether you are raising with regard to the equity shares or the preferential shares, equity with the voting rights, equity with the differential voting rights, or redeemable shares or irredeemable shares. So capital structure of the company will be made very clear, whereby the investor will come to know, okay, this is what the capital structure of the company as such. So the point here is that the investor should come to know well in advance about the information of the companies. Then object of the public offer. That means what purpose they are raising the capital. So object of the public offer is also being raised, followed by main object and present business of the company. This will raise the two important principles. Unless otherwise objects are permitted by the MOA, the company may not go to the public to raise the capital. If the company raises the capital which is not permitted by the object, this comes under doctrine of ultra vires. This also brings the liability of the companies. So it has to be made very clear about the main objects of the present business which is permitted by MOA. So the contents of the prospectus should be related to the contents of the MOA objects. Then another information about the risk factors. Basically, this is provided with regard to the investors' education, or investor will come to an understanding called all the investors required to take informed decisions, right? Investors are required to understand the informed decisions. Therefore, the risk factor, what are the project, how the completion of the project, where the money or the capital which is being collected will be invested also, will look into that informations. So if you see the what we discussed just now, basically it comes as the general information of the company, about the directors, about the underwriters, about the capital structure, about the risk factors. The second part of the prospectus is about the financial information. The financial information is very important. Every investor who is investing in a company should know that about the capital structure, and the sense the profit and loss account, the balance sheet, how the profit and loss account is there. That means what are the number of years where there is the huge profits or the losses. And this also try to understand as which we call about the financial health, about the financial health of the company, which may talk about the also another wealth of the companies, right? Financial health and financial wealth. So by understanding, by looking the information, the investors will come to know, yes, this company has good financial health, therefore investors can make investments. Then another concept is that a declaration by the company that a company is adhering to the another two important regulations. That is, a company which is going for a public offer through prospectus, or making the prospectus and making the public offer, has to follow the regulations which are provided under the SEBI Act and also under Securities Contract Act. Then in the relation to these legislation, company has to make a declaration that is called the declarations on compliance, we call as the due diligence reports. This is the common term which we use in the aspects of the internships when the students want to make due diligence or the financial status of the company, whether they are following about the certain adherence of the regulations, whether rules are being adhered or not. So company has to make a statement that the company is following the rules under the SEBI regulations as well as the securities contract law. And every prospectus which has prepared, it has to inform and deliver to the registrar of the company. That's what we call as publication of prospectus. If the prospectus is prepared, say for example today, that is on 16/10/2022, if it is being submitted to the registrar of the company, the prospectus is valid 90 days. Please remember, once the prospectus is prepared, the prospectus validity is 90 days. Within 90 days, it can go to the public. In case of any major changes in the prospectus, they can inform by virtue of the information memorandum or other documents are provided. The point is called, there is called as validity of prospectus. So once you prepare a prospectus, the prospectus need to be submitted to the one copy to registrar, then another copy to SEBI, then also another copy to what we call about the stock markets where we are going to be listed. So a prospectus need to be submitted to the registrar, stock exchange, then it will also move to the SEBI. It is very important, once you submit, it comes as a date which we call it as a date of publications. The reason for the date of publication is the very prospectus has a validity. That's what under section 26, right? Section 26, clause number 6, which we are talking, has been delivered for registration to the registrar as required under the subsection number 4. No subscription, no prospectus shall be valid issued more than 90 days. So 90 days is given under the section 26, clause number 8. Section 26, clause number 8 makes very clear the validity of the prospectus is only 90 days. If any prospectus is issued beyond the 90 days, it comes as a prospectus issued beyond the permissible rules, then that automatically becomes invalidity of the prospectus, or what we call about a prospectus which is issued not permitted by the law. Now, these are all the concepts which we see the information on the prospectus. So the prospectus contents are being divided. One is the general information, other one is about the financial informations. Once contents are there, and if the contents are untrue, if the contents are not truthful, then automatically the other concept applies, what is called about the liability. If there are statements which you have made, the statements made by the company, if the statements are untrue, if the statements are misstatements, the other concept comes liability. The liability comes who is liable for the statements. Then we read in company law, liability for the statements made. One is the company itself is liable. The other one is the persons responsible for statements, right? What we are talking about, persons responsible. In the case of any company is existing in a legal fiction. In real sense, it is functioning with the individuals. Let us see what the company law talks. Thereafter, we can look into the principles of corporate law. This is very, very important concept, because majority of the legal disputes are the cases which comes before the court of law. We find about the investors who invested on the statements given by the company, when the statements are not true, when the statements are false or untrue statements. Now, the first liability is a criminal liability for the misstatements in the prospectus. What is the criminal liability? When the prospectus is issued, right? When the prospectus is issued, 1, circulated, number 2, 3, distributed, includes any statement which is untrue, which is misleading in form and context, any inclusion or any of the omissions, then they become liable under 447. Now section 434 says, if the statement which is issued, circulated or distributed, though they look like the synonymous in English terminology, both more or less talks about issuing of the prospectus. Circulated means it is being circulated through the red herring prospectus. Distribution also comes circulating of a document prior to the publication of the final prospectus, where people will believe. In a simple terms, once a prospectus has been printed or issued and later people will come to know the statements are false, then the question will come, what is the liability? Under 34, section 34 refers to the section 447. So what is the punishment in 447? 447 is a fraud which talks about 10 years imprisonment. So for the untrue statements by the company while issuing of the prospectus, the liability is the criminal liability. One of the fundamental question will come, In the case of criminal liability of the prospectus, whether is it possible to send the company, that is, company in the sense a legal personality, how do you send legal personality to the jail? Because they have to go to the imprisonment. Then in that case, the lifting of veil can be done. The real persons who are responsible for the untrue statements, these people will become criminal liable statements. Because what is that? Today's corporate frauds, corporate offenses have been taken very seriously by the regulatory bodies, by the lawmakers, that no person should be escaped from the liabilities. So the civil liability they talk about authorizes issue of particular prospectus. This is a very important con. Every person who authorizes issue of such prospectus. If I give one of the example, the person authorized for issue of a prospectus may be one of the directors or the expert or maybe authorized signatories. We find these people who has been authorized. So the persons who are authorized to issue the prospectus, then you have the liability under the provisions of law that we can see about the section 447, their liability comes. So try to remember section 34 of the criminal liability refers to 447. Section 447 of the Companies Act talks about the punishment for the fraud. Now let us see another provision. Civil liability. Section 35 of the Companies Act talks about the civil liability for the misstatements in the prospectus. Now, when you see the section 35 clause number 1, I am reading the provision. Clause number 1 talks where a person has subscribed to the securities of a company acting on any statement included. Now let us have an example. You have X Limited company. Mr. A subscribed the shares from this particular company. A has come to know the statements in the prospectus are untrue, right? Now A wishes to bring the claim or A wishes to file petition on X Limited because the statements which were there are untrue statements. Now Mr. A thinks on about the liabilities. So Mr. A is provided a remedy under section 35 on X Limited, and where he can file on X Limited, that X Limited should be civil liable or maybe the civil liabilities. One of the legal vacuum is that for what gravity or nature of the offenses, the parties can go for a civil liability or a criminal liability. It is given to the parties by looking into the gravity of a particular act, by looking into the nature of the fraud committed or nature of the wrong happened, and also the quantum of damage and quantum of compensation which are required by the investors or the loss suffered by them. So that's why they have written here, which is a misleading, and where if is a Mr. A is a party and Mr. A had a loss or the damage as a consequences, then the people who are being responsible, then the people which will say, number 1, the director of the company is responsible, authorized person is responsible, promoter of the company is responsible, and any authorized person issue of the prospectus are responsible. So therefore, section 35 provides in the broader terminology on the classifications of the section 35. If I put it very briefly, director of the company, promoter of the company, a person authorized by the company to issue the prospectus, these 3 people are liable for any of the misstatements under the civil liabilities. And there is also requirement to show that the person who is filing the case should have certain damages occurred, then only he has the right to file the case. So, section 34 criminal liability, 35 civil liability. Now, exemptions. Let us take another hypothetical problem. A files a case on X Limited, right, making liability of Y, who is the director of the company. If Y is approaching lawyer, what remedies are available to me having no liabilities, right? Let us see. A is an investor, files a case in X Limited, asking the Y director should be liable because he issued the statement. Now let us see about the grounds for the A. Let us see about the director. A can claim when director made a statement which is untrue, which is misleading, right? And also which is malified intentions. That's what they provide in law. If the statement has untrue, misleading, malified intention, automatically the director becomes liable. If you are approaching the directors, right, who is Y, what grounds you are there for the director that he is not liable? So, section 35 clause number 2 comes as a defense. Defense to a persons. What are those defenses? No person shall be liable under subsection 2, subsection 1, if he proves that having consented to become a director of the company, withdraw the consent before issuing of the prospectus, was issued without his authority or a consent, prospectus was issued without his knowledge or a consent, right? So, if the director makes and proves the statement was issued without my knowledge, number 1. Second, even though statement was issued with the knowledge, later the person has come to know that the statement was untrue. If the director makes a public notice that I am not responsible for a particular statement because the statement was given by the company, I came to know that there is some untrue statements, then he gives a public notice. So that comes as an exceptions. And once he has given a consent, withdraw the consent. You may have a doubt like this. When he will withdraw the consent? Why he will withdraw the consent? As we have seen in the commencement of our class, the validity of the prospectus is 90 days, right? The validity is 90 days. Within 90 days, lot of changes may happen in any companies, right? The validity of the prospectus is 90 days. If a meeting was held, some statements were there. So when the people will come to know the statements are wrong, then automatically they can withdraw their consents. So exceptions are exemptions. Exception to liability. The exemption to liability are that when the prospectus was issued, even after publication of the prospectus, director has makes a statement after becoming aware of the statement that he withdraw the consent by giving of the public notice. So kindly remember section 35 clause 2, right? Section 35 clause 2 provides the defenses for non-liabilities. Section 35 provides in the same proviso itself liability for the misstatements. It also provides at the same time when a person is not liable. Either you may be a lawyer, you may be chartered accountant, or the company secretary. When the parties will come to us, one of the party may be like investor will approach you or the director will approach you. We don't know that who will approach the lawyer sometimes. He affected investor may approach or an affected director will approach. If there is a reasonable belief, a reasonable case, and law has provided when non-liability comes, then when liabilities comes. Let us move further on the liabilities part, on the punishment parts. So section 36 about the inducing of persons on about the material facts, because actually what happens is that it is about the fraudulent investing to somebody to invest. This I don't require to discuss on the misstatements. Now let me take one of the prominent case on the Prospectus chapter is the on deceit. The name of the case is Derry versus Peak. And the facts are given very briefly here. The prospectus of a company stated that company had been authorized to use steam power in moving its trams. The authority was in fact subject to the approval of the Board of Trade, which refused its approval. So facts I have given in 2 lines. A company published the prospectus where it said that it can run its business or the tram engines by using of the steam power subject to the approval of the Board of Trade. However, there was no approvals. To put it in a simple facts, a company which has published the statement for a purpose of doing a particular business on a condition that if they get the permission from the government or authority. When the authority has not given approval, when the grant was not granted by a particular competent authority, whether that becomes as a misstatements or not, whether the director becomes liable or not. In this case, the UK court has said they are not liable because they are not guilty of the fraud. They comes with one of the interesting terminology that is called as honest mistake. Those who are really interested to learn the law, this is the new point which comes to understand. It is a mistake, but not the what is called about the modified mistake. It was not amount to a fraud, but the mistake which was done is an honest mistake, therefore they are not being liable. So therefore they said directors held not liable. Directors are not to be guilty because they were honest, where their fraud requires a statement which makers know to be false, does not believe to be true, or a statement which is made recklessly, right? This is not the statement of recklessness or as to the truth. So the statement made in this case, they know that they were waiting for the permission, subject to the permission of the authorities that they are going to run the business. And the House of Lords has found an important principle, that is honest mistake. Honest mistake is the principle which we can carry out where one of the exemption to the liability will come, which you can make it. Though this case was criticized by some of the judges, by some of the scholars, because the statement which was made was not true at the time of publication of the prospectus. They were waiting for the permission, but the permission was not received. The important point which we can carry, if the 2022, this is a judgment of 1889, we are in 2022. Why should we read this judgment in 2022? The principle of 1889, which carries even today, is about a exception on liability, that is honest mistake. In the case of the promoters or the directors or authorized persons, if they do some activity with a bona fide intention, they will always have what is called as the non-liability on the ground of this particular principle. We will discuss one more case, then we will try to conclude today's lecture. The another case is R versus Clysant, and it is also a very important case. Here in this case, the company published a prospectus, and in the prospectus they said in 1911 to 1927 they paid and declared dividends. Right? The statement what they said, company declaration of dividends 1911 to 1927. And in the year 1921, company has some losses. The statement regarding to the losses were not informed. The statement regarding to the losses were not published. The truth was that the company declared the dividend, company paid the dividend these years. There is no wrong statement on that. The wrong statement out of that was that when the company paid the dividends during the loss period, the company paid the dividend during the loss out of previous years, right? Previous year reserves. If the company paid the dividend even during the losses out of previous year's reserves, the company has to make a statement, because what will happen, the people who are purchasing the shares, by looking into the statement, the presumption comes. The presumption is that if the company pays the dividend for a period of 8 years, that means it is having the profits. The general understanding is that dividends are paid out of the profits. If the statement is that company paid the dividends from 1911 to 1927, that means company is running with a profitable business. And the wrong impression is that the people who have invested in the company later came to know that on a particular point of time there were losses. Therefore, in this case, it was held that this statement is misleading in the prospectus, and the people who issued and the people becomes liable. So the point which was raised down R versus client case, suppression of the facts, right? Suppression of the facts. Suppression of the facts is that when the company paid the dividends during the loss period, when the company paid the dividends during the loss period, it has to say, or it has to mention that it paid the dividends during the loss out of the previous year's reserves. However, it has not made it. So therefore, the court said this becomes untrue statements. If you see the two cases, Derry versus Peak case, it was a case of honest mistake. There was no liability. Second one is suppression of the facts, non-disclosure of the losses amounts to the liability also. Now, there are another 2 to 3 case laws. What I will do, I will keep some more lectures for specially for the case laws. On the misstatement of the prospectus, there are 2 more case laws, or maybe more than 2 case laws, Sahara case and DLF judgment. To explain this DLF case, it requires maybe another 25 to 30 minutes. So therefore, we will discuss in the another class. So this particular lectures what we have read, to briefly bring back to you is that section 26, contents, section 35, right, section 36, section 34 on liabilities. Then we also talked about 2 landmark cases. Those are Derry versus Peak, as well as R versus Clysant. And in the contents, we have discussed about general informations and the financial informations. liability, civil and criminal liability. Then we also talked about the exception to the liabilities, right? Exceptional liability we discussed. So in the next lectures, we will discuss some more cases on the prospectus and also other types of the prospectus. Thank you for patiently listening. Kindly provide your comments and any suggestions if you readers, after listening the lecture, if you want to make some more constructive comments whereby I will include in my further lectures. Thank you all. We will meet again in the next lecture on the types of the prospectus as well as liability.